You're watching The Legal Breakdown. So, Glenn, we've got a breaking ruling that was just handed down by Judge Cohen in the Florida classified documents case. What just happened in that case?
So Donald Trump's co-defendant, one of them, Waltine Nauta, his so-called body man and box carrier, he filed the motion to have his case dismissed based on selective prosecution or vindictive prosecution. Those are very sort of closely associated legal motions, and Judge Cohen denied the motion to dismiss. And here's what I'm going to say, Brian. I read the 4-page ruling by Judge Cohen. It actually read as if somebody else had written it. It read like a legitimate, understandable, well-supported in the law legal ruling. And I have to tell you, I've read all of Judge Cohen's rulings, and we haven't really seen any that I would call a run-of-the-mill ruling. This one was. It was short, 4 pages, to the point. It cited the pertinent authority in just squarely and easily rejecting co-defendant Walt Nauta's claim of selective and vindictive prosecution. And, bravo for Judge Cohen, once doing something that's sort of a normal, rational, fair, impartial, and independent judge would do.
Which suggests that perhaps when it's not Donald Trump who's on the indictment, that she might actually be capable of being a judge. And yet, with that said, let's talk about what she said with regard to Donald Trump, because she added, very notably, I would add, that this motion to dismiss shall not be construed as commenting on the merits of defendant Trump's motion to dismiss. But if these people were both involved in the same prosecution for committing the same underlying crime, how could she deny the merits of Walt Nauta's claim and yet retain this ability to suggest that Donald Trump still might have a case here?
Yeah, great question, Brian, and there's quite a bit to unpack there. So first of all, let's start with what I think is the obvious. That was not something she should have included in the motion. Why do I say that? Because she was only deciding defendant Walt Nauta's motion to dismiss based on selective and vindictive prosecution. Had nothing to do, really, with Donald Trump.
Right. It's almost like she's bending over backwards to, even when it has nothing to do with Trump, to show her deference to him.
Bingo. Sending him a signal that, hey, I still got you, defendant Don. Don't worry, I haven't ruled on your motion, and this denial shouldn't be construed as me, potentially ruling against you in the future. So it should not have been included in there. But to answer your question, because the same motion, I think, has been raised by all defendants, will be litigated and resolved with respect to all defendants. But actually, in the arena of selective prosecution, you need to look at each of the defendants individually, even if they're co-defendants and they are involved in joint criminal conduct. And here's why. There are 2 things that a defendant has to prove by clear and convincing evidence if he is to be successful in the area of selective or vindictive prosecution. First of all, he would have to prove that similarly situated people who had committed similar crimes to Walt Nauta. I know it begs the question, is Walt Nauta's crime similar to that of Donald Trump or different? I would say it's both for lots of reasons. But the first prong that must be satisfied by evidence that Walt Nauta presents is that similarly situated people were not prosecuted, and 2, that the prosecution of Nauta by Jack Smith had a discriminatory purpose. You need both of those prongs to be satisfied in order for a defendant to have a successful selective prosecution claim. And Judge Cohen plainly stated, in accordance with the evidence, he satisfies neither of the 2 prongs. Motion denied. However, although that may seem relevant to a selective prosecution claim by Donald Trump, it really is completely an independent question whether, for example, similarly situated people were not prosecuted when Donald Trump was. Well, he's in a category of 1. There are no other former presidents who stole classified documents from the American people, from the federal government, obstructed justice to, defy a grand jury subpoena requiring their return, and committing espionage crimes. So there are no similarly situated people that Donald Trump can be compared to. And then, of course, the prosecution of Donald Trump is not for a discriminatory purpose, notwithstanding how much he will yell and scream and lie about, the claim that it is. So they're related, but they really need to be resolved separately with different evidentiary hearings. But here's the thing. Let's go back to where we started. There was absolutely no reason for her to drop in the very end of her motion. By the way, Don, this has nothing to do with your pending claim, your pending motion to dismiss based on selective prosecution. That was a shout out to the defendant that was at best inappropriate and at worst, a continued indication that the fix is in.
Glenn, if Walt Nauda's claim wasn't dismissed and he was but a mere foot soldier of the guy who actually ordered this whole thing, the guy for whom this whole operation was facilitated by, does that suggest that there would be very little likelihood that Donald Trump's claim would be dismissed as well? Because like I said, Walt Nauta didn't facilitate any of this. He didn't order any of this into motion, but Donald Trump did. And so if his claim is still valid, wouldn't logic have it that Trump's would be too?
Relevant but not dispositive is what I would say. For example, let's assume Donald Trump had, boatloads of evidence that he was being prosecuted for a discriminatory purpose, which he's not. That could sort of set apart from Walt Nauta Donald Trump's selective prosecution claim. But you're right. Atmospherically, these things are related. Sort of factually, these things are related. And Donald Trump will not be able to carry his burden to prove that his case should be dismissed because he's being selectively or vindictively prosecuted.
Right. It kind of reminds me of the Michael Cohen situation with the cooking the books to hide the hush money payout, because Michael Cohen was successfully prosecuted for being, again, a foot soldier of Donald Trump, and yet that case was rightfully decided where Donald Trump, who obviously facilitated that whole crime, was held to account as well. So it would be so bizarre if Michael Cohen was sentenced to prison, convicted and then sentenced to prison for his role in a scheme that was ultimately orchestrated by the main defendant here, who was Donald Trump.
Yeah, and similarly, can you imagine how we would feel about the equal application of our laws and the prospect of fair and equal justice if Walt Nauta and Carlos de Oliveira, Donald Trump's two co-defendants who did his criminal, dirty work for him, got convicted and Donald Trump wasn't held accountable? When Judge Cannon is the one presiding over this co-defendant trial, there is nothing off the table with respect to how she will ultimately potentially orchestrate, continued favors for Donald Trump.
Based on this ruling not to dismiss the case against Walt Nauta, is there anything that you can read from the tea leaves here as far as Trump is concerned? Or conversely, does the fact that she, apropos of nothing, included this little nudge, this little message to Donald Trump saying that this has nothing to do with his motion to dismiss, can you read anything from the tea leaves there? Like, either way, one way or the other, is there anything that you can glean from this?
Yeah, I'm often finding reasons to conclude that Judge Cannon should be removed from presiding over the case. Why? Because the federal law says if a judge's impartiality might reasonably be questioned, she is required to disqualify herself. In this one, even though I think it was unfortunate but not surprising that she, sent that message to Donald Trump in the last sentence of, the denying Walt Nauta's motion to dismiss, that was inappropriate. I don't think you can really glean much about what she's going to do moving forward with Trump's motion to dismiss on similar grounds.
Now, if she does, gaming this out, if she were to dismiss Donald Trump's claims, suggesting that this is a vindictive prosecution, would that be the inciting incident that it would take for Jack Smith to then go to the 11th Circuit Court of Appeals and seek her removal? Because we have all of these instances where Judge Cannon seems to go right up to the line, probably as far as Jack Smith is concerned, even though we can make the argument that she's already exceeded the line in a number of these situations, but goes right up to the line and doesn't do something so egregious that it would be an immediate grounds for her recusal. But would her dismissing the case based on this motion be enough of a grounds for Jack Smith to then say, you know what, like my red line is crossed?
I would say a definitive yes. He would appeal any ruling that dismissed Donald Trump's case based on a selective or vindictive prosecution claim, and I suspect he would win on appeal and the case would be reinstated. That is, her granting the motion to dismiss would be reversed. But the thing is, Brian, as we now know, based on some other recent developments, there are lots of other motions and there's lots of other brand new litigation kicking around that make this issue, selective prosecution, look like small potatoes with respect to what Judge Cannon might be able to do to tank the case against Donald Trump, because now you've got Donald Trump's imperial court ruling that Donald Trump is, in essence, a king, as is every other president. They are, above and beyond the reach of our nation's criminal laws. So all of that is now going to be litigated in the context of the Florida documents case. And of course, don't forget, in the President is King ruling, you had Justice Thomas, Clarence Thomas, also send the message to Judge Cannon that, I suggest you might want to look at whether Jack Smith was lawfully appointed in the first place. So now there are other bigger issues kicking around that will be litigated by Judge Cannon. When? Nobody knows. But, and I think it will make the selective prosecution issue look like small potatoes.
Just digging into that for a quick moment. Is there a way to rectify the situation? Let's say, for example, that Jack Smith, that Clarence Thomas is able to convince Judge Cannon and the rest of enough justices on the Supreme Court that he was unconstitutionally appointed as a prosecutor, that a special counsel isn't allowed to prosecute these cases. Would the Justice Department be able to pick up this case where it left off, for example, and kind of swap out Jack Smith so it's no longer a special counsel prosecuting this case, but rather just a direct representative of the U.S. government, of the DOJ?
Yeah, the answer is yes. If there is a defect in the appointment or the status of a prosecutor that impacts the legality of that prosecution moving forward, you're exactly right. The remedy is to cure the defect by having, a regular federal prosecutor from the Department of Justice assume responsibility for the case. All of this is kind of uncharted territory, so I'm sure the defendants would make a motion to dismiss with prejudice, saying these are defects that can't be cured because too much damage has already been done by an unlawfully appointed special counsel. But I think at the end of the day, and let me tell you, Jack Smith and I believe the Department of Justice are in this for the long haul. I hate to even say this, Brian, 2, 3, 4, maybe even 5 years from now, we will probably be doing legal breakdown segments about the current status of the Trump trials. But you know what? I'm here for it if it takes a decade, however long it takes, to vindicate the rights of the American people. When Donald Trump tried to steal an election from the voters, as long as it takes, we have to keep moving in the direction of justice.
We'll leave it there. For those watching right now, if you want to be able to follow along for as long as these prosecutions take, please make sure to subscribe. The links to both of our channels are right here on the screen. Glenn is on his way up to 1 million subscribers, so if you're not yet subscribed to his channel, please go ahead and hit the subscribe button. And my channel as well is very close to 3 million, so if you're not yet subscribed to this channel, also make sure to subscribe here. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.